Contracts are the foundation of any construction project, and understanding the general principles of contract law in Malaysia is crucial for all parties involved in the construction industry. In this video, we will cover the general principles of contract law in Malaysia, quoting various relevant acts. The first principle is offer and acceptance. In Malaysia, an offer is an expression of willingness to contract on specific terms made with the intention that it shall become binding as soon as it is accepted by the party to whom it is addressed. The acceptance must be communicated to the offerer. And it must be unconditional. And in accordance with the terms of the offer. These principles are set out in Section 2A of the Contracts Act 1950. The second principle is consideration. In Malaysia, consideration is defined as the price paid by one party for the promise of the other party to do or not to do something. It must be sufficient but need not be adequate. It can be in the form of money, goods, services, or anything else of value. These principles are set out in Section 26 of the Contracts Act 1950. The third principle is legality. The contract must not be contrary to the laws of Malaysia or public policy. Contracts that are illegal or against public policy are void and unenforceable. These principles are set out in Section 24 of the Contracts Act 1950. The fourth principle is capacity. The parties to the contract must have the legal capacity to enter into it. In Malaysia, minors, persons of unsound mind, and undischarged bankrupts are generally considered to lack the capacity to contract. These principles are set out in Section 11 of the Contracts Act 1950. The fifth principle is intention. The parties must have the intention to create a legally binding agreement. In Malaysia, contracts that are vague or uncertain in their terms or where the parties do not intend to create legal relations are not enforceable. These principles are set out in Section 10 of the Contracts Act 1950. The next important principle is the doctrine of privity of contract. This means that only the parties to a contract can enforce it. This principle is enshrined in the Contracts, Privity, Act 1984. Another important principle is the doctrine of frustration. This means that a contract may be discharged if unforeseen events occur that make it impossible to perform the contract or if the purpose of the contract is frustrated. This principle is set out in Section 57 of the Contracts Act 1950. Another important principle is the doctrine of breach of contract. This means that if one party fails to perform their obligations under the contract, the other party may be entitled to damages or specific performance. This principle is set out in Section 74 of the Contracts Act 1950. It's important to note that construction contracts are often complex and require specialized knowledge. Therefore, it's important to seek legal advice when drafting or entering into a construction contract. This can help to avoid disputes and ensure that the contract is enforceable. Understanding the general principles of contract law in Malaysia is crucial for anyone involved in the construction industry. These principles include offer and acceptance, consideration, legality, capacity, and intention. By following these principles, you can ensure that your contracts are valid, enforceable, and protect your interests in the Malaysian construction industry. Contracts are legally binding agreements between two or more parties, and they are essential in the construction industry to ensure that projects are completed on time, within budget, and to the required standard. In this video, we will discuss the nature and classification of contract terms, the difference between express and implied terms, the relative significance of terms, exclusion clauses, and limitation of liability in construction contracts in Malaysia. We will also quote relevant clauses to illustrate their importance. The nature and classification of contract terms are crucial in construction contracts. There are two main types of contract terms: conditions and warranties. A condition is a fundamental term of the contract that goes to the root of the agreement. A warranty, on the other hand, is a secondary term that is not fundamental to the agreement. For example, Clause 2.1 of the PAM Contract 2006 states that the contractor shall carry out and complete the works in accordance with the contract. This is a condition of the contract as it goes to the root of the agreement. Express terms are those that are explicitly stated in the contract, either orally or in writing. Implied terms are those that are not explicitly stated but are inferred from the conduct of the parties or from the nature of the agreement. For example, Clause 4.2 of the JKR Form of Contract, P. W. D. 203A, Rev. 2015, states that the contractor shall ensure that all materials and workmanship used in the works are of good quality and in accordance with the contract. This is an express term of the contract. The relative significance of terms refers to the importance of the different terms in the contract. Some terms may be more significant than others, depending on the nature of the agreement. For example, Clause 6.3 of the CIDB Standard Form of Contract for Design and Build Projects, 2014, states that the contractor shall indemnify the employer against all claims, damages, and losses arising from the contractor's negligence. This is a significant term of the contract as it deals with the contractor's liability for any negligence. Exclusion clauses are terms that exclude or limit a party's liability for certain events or circumstances. These clauses are often used to limit the liability of contractors for defects or delays in the construction project. However, such clauses must be reasonable and not too broad in scope. For example, Clause 15.1 of the PAM Contract 2006 states that the contractor shall not be liable for any loss or damage suffered by the employer as a result of any act or omission of the architect. This is an exclusion clause that limits the contractor's liability for the architect's actions or omissions. Limitation of liability clauses are used to limit the amount of damages that a party may be liable for in the event of a breach of contract. However, such clauses must be reasonable and not too broad in scope. For example, Clause 18.3 of the JKR Form of Contract, PWD 203A, Revision 2015, states that the contractor's liability for breach of contract shall be limited to the contract price. This is a limitation of liability clause that limits the contractor's liability to the contract price. The term of contract is a crucial aspect of any construction project in Malaysia. Understanding the different types of contract terms, and the relevant clauses that are used to illustrate their importance, is essential to ensuring that construction projects are completed on time, within budget, and to the required standard. If you are unsure about any aspect of a construction contract, it is important to seek legal advice before signing the agreement. This can help to ensure that the terms of the contract are fair and reasonable, and that you are aware of your rights and obligations under the agreement. Contracts are legally binding agreements between two or more parties, and they are essential in the construction industry to ensure that projects are completed on time, within budget, and to the required standard. In this video, we will discuss the methods of discharging a contract and quote relevant clauses in construction law in Malaysia to illustrate their importance. Discharge by performance occurs when both parties have fulfilled their contractual obligations. In the construction industry, this may occur when the contractor completes the project according to the agreed upon specifications and the employer pays the agreed upon amount. For example, Clause 2.1 of the PAM Contract 2006 states that the contractor shall carry out and complete the works in accordance with the contract. Once the contractor has completed the works, the contract is discharged by performance. Discharge by agreement occurs when both parties agree to terminate the contract before the completion of the project. This may occur when there is a change in circumstances or when both parties agree that it is in their best interest to terminate the contract. For example, Clause 13.1 of the JKR Form of Contract, PWD 203A, Revision 2015, states that either party may terminate the contract by giving written notice to the other party if the other party commits a breach of contract. If both parties agree to terminate the contract, then the contract is discharged by agreement. Discharge by frustration occurs when unforeseeable events occur that make it impossible to perform the contract. In the construction industry, this may occur when a natural disaster, such as a flood or earthquake, makes it impossible to complete the project. For example, Clause 16.1 of the CIDB Standard Form of Contract for Design and Build Projects, 2014, states that if the works are destroyed or damaged by any cause beyond the control of the contractor, then the contract shall be deemed to be frustrated. Discharge by breach occurs when one party fails to fulfill their contractual obligations. In the construction industry, this may occur when the contractor fails to complete the project according to the agreed upon specifications or when the employer fails to pay the agreed upon amount. For example, Clause 4.2 of the JKR Form of Contract, PWD 203A, Revision 2015, states that the contractor shall ensure that all materials and workmanship used in the works are of good quality and in accordance with the contract. If the contractor fails to ensure the quality of the materials and workmanship, then the contract is discharged by breach. Discharge by performance and breach occurs when one party performs their contractual obligations but also breaches the contract in some way. In the construction industry, this may occur when the contractor completes the project but uses substandard materials, which breach the contract. For example, Clause 15.1 of the PAM Contract 2006 states that the contractor shall not be liable for any loss or damage suffered by the employer as a result of any act or omission of the architect. If the architect breaches the contract, but the contractor has completed the works according to the contract. Then the contract is discharged by performance and breach. The discharge of a contract is an essential aspect of any construction project in Malaysia. Understanding the methods of discharge, including discharge by performance, discharge by agreement, discharge by frustration, discharge by breach, and discharge by performance and breach, is crucial to ensuring that construction projects are completed successfully. By understanding the relevant clauses. Contracts are legally binding agreements between two or more parties, and they are essential in the construction industry to ensure that projects are completed on time, within budget, and to the required standard. We will discuss the principal remedies for breach of contract in construction law, including damages, specific performance, and injunctions, and quote relevant clauses in construction law in Malaysia to illustrate their importance. Damages are the most common remedy for breach of contract in construction law. Damages are intended to compensate the non-breaching party for any losses suffered as a result of the breach of contract. In the construction industry, damages may include costs incurred as a result of the breach, such as the cost of remedying defects or delays caused by the breach. For example, Clause 24.1 of the JKR Form of Contract, PWD 203A, Revision 2015, states that if the contractor breaches the contract, the employer may claim damages for any loss or damage suffered as a result of the breach. Specific performance is a remedy that requires the breaching party to perform their contractual obligations. In the construction industry, specific performance may be used when the non-breaching party requires the contractor to complete the project according to the agreed-upon specifications. For example, Clause 30.3 of the PAM Contract 2006 states that if the contractor breaches the contract by failing to complete the works, the employer may require the contractor to complete the works within a specified time. Injunctions are a remedy that prevents the breaching party from continuing to breach the contract. In the construction industry, injunctions may be used when the contractor breaches the contract by using substandard materials or when the employer breaches the contract by interfering with the contractor's work. For example, Clause 24.2 of the JKR Form of Contract, PWD 203A, Revision 2015, states that if the contractor breaches the contract, the employer may seek an injunction to prevent the contractor from continuing the breach. Liquidated damages are a type of damages that are predetermined in the contract. Liquidated damages are often used in the construction industry to compensate the non-breaching party for delays caused by the breach of contract. For example, Clause 23.2 of the PAM Contract 2006 states that if the contractor fails to complete the works by the specified date, the employer is entitled to claim liquidated damages per day at the rate specified in the condition of contract. Termination is a remedy that allows either party to terminate the contract in the event of a breach. In the construction industry, termination may be used when the contractor breaches the contract by failing to complete the project or when the employer breaches the contract by failing to pay the agreed-upon amount. For example, Clause 11.2 of the CIDB Standard Form of Contract for Design and Build Projects, 2014, states that if the contractor breaches the contract by failing to complete the works, the employer may terminate the contract. Understanding the principal remedies for breach of contract in construction law is essential for both employers and contractors in Malaysia. The remedies discussed in this video, including damages, specific performance, injunctions, liquidated damages, and termination, provide a range of options for addressing breaches of contract in the construction industry. By understanding the relevant clauses in construction law, employers and contractors can protect themselves and ensure that construction projects are completed successfully. Thank you for tuning in. In the upcoming Chapter 3, we will delve into the law of tort and its connection to the construction industry in Malaysia. Make sure to stay subscribed, like, and share our video.